Okay. Hello, everyone. I make it 3 o'clock, so I suggest we begin. Thank you, everyone, for joining us this afternoon. My name is Catherine Holden. I'm Associate Director at techUK for Data Analytics, Artificial Intelligence and Digital Identity at techUK. And I'm delighted to invite you to this panel today, where we'll be looking at how UK businesses can best prepare for the EU AI Act. And for those of you that haven't seen, you must have been living under a rock, that earlier this month, the European Parliament voted overwhelmingly to approve the EU AI Act. So very much progressing at pace. And we have a brilliant lineup of panelists today to join us to really unpack what this means for businesses in the UK, but also operating abroad, and how you can, as I said, best prepare for what's to come. So we're keen to make sure this session is as interactive as possible. I have a number of questions I'd love to ask the panel, but if you have any questions specifically for the panel, then please do pop them in the chat and I will monitor that throughout the course of the next hour or so. So maybe I might get my panel to introduce themselves, because I always think that's the best way to start. So maybe, Tim, if I could come to you first, would you mind giving us maybe a brief introduction to yourself, your organisation, but also, I guess, your experience in relation to the EU AI Act?
So Tim McGar, I'm the AI Market Development Lead in BSI. So BSI does a number of things. We are the UK National Standards Body, which is where the part of BSI used to work in. And we also do things like conformity assessment. And I now work in the regulatory services side, which I'll come to in a second. So in terms of some of my experiences, it relates to the topic for today. So there are standards that will provide a presumption of conformity to the EU AI Act, and I can cover some of that later on. In my current team, we are working towards becoming an AI notified body, which is a role set out in the EU AI Act. And as we'll probably come to again, for some products, organisations will need to work with an AI notified body to get their products onto the market in the EU. We're also offering some of the elements around that already, like so part of other notified body services or algorithm auditing, and offering certification against the AI Management System Standard 42001, which again we'll probably come back to around some of the processes organisations need to go through.
Thanks, Tim. Maybe Dan, if I could come to you next.
Yeah, sure. So hi everyone, I'm Dan Whitehead. I'm counsel at Hogan Lovells, an international law firm, and I work in our global regulatory practice. My practice is going to focus on two main areas. One is cybersecurity, including incident response and regulatory issues relating to cybersecurity, and the other increasingly is artificial intelligence and how do you build governance structures and compliance around both existing regulations that apply to artificial intelligence, but also new laws such as what we're considering today with the EU AI Act. We work for a large number of clients in sectors including technology, financial services, life sciences, on helping them to kind of understand what the regulation means and how best to prepare for it. I'm also a member of the Law Society's AI working group here in the UK, which is focused on kind of how, from a big picture perspective, the legal industry may change and evolve with the adoption of artificial intelligence into our practice areas.
Excellent. Thanks, Dan. Thanks for joining us. Maybe Isabel, if I could come to you next.
Thanks, Catherine. Hi, everybody. Thanks for having me here today. My name's Isabel Simpson. I'm the EMA Head of Data, Digital and Technology Practice Group for KPMG Law. That really means that I specialise in providing clients with advice on how they comply with data protection regulation, and then now more latterly around all the new digital online safety, operational resilience, and also AI regulation as well. And the areas where we help organisations is we think about how do they look at all of these laws in a holistic way, and how do they take their compliance programs and legal frameworks and then uplift those to ensure compliance with the AI Act and other regulations.
Excellent. Thank you, Isabel. And last but not least, Osman, across to you.
Thanks, Catherine. Hi, everyone. My name is Osman Gazi Güçlütürk, and I'm legal and regulatory lead at Holistic AI. Holistic AI is a London-based AI governance firm. We have product and I'm a lawyer by education, but currently at the firm, I'm actually working together with our product team and improving our product in a manner that would actually turn those into EU Act preparedness tools. Prior to joining Holistic, I did postdoc on EU Act and copyright at Yale, and before that, I did my PhD on EU Act. So that's basically my life now, and it's a pleasure to be here today with you.
Thank you, Osman. And let's dive straight into it. We've only got sort of 55 minutes and there's a lot to cover. So maybe, Dan, if I could come back to you to start with, could you help us by maybe starting to sort of set the scene, giving us a bit of background on the Act? You know, where's this kind of come from? What are its overall kind of aims and objectives?
Sure. So back during the COVID pandemic, April 2021 is, I think, where this all properly began, where the initial commission draft of the AI Act was published, and that set out this new framework, which is based on the EU's harmonized standards and product safety framework for AI systems. The proposal has since, as I'm sure many people on this call are fully aware, evolved somewhat, partially taking into account the way that AI has evolved and the technology. So legislators are continuously trying to keep up, and there's been various amendments that have been proposed, some agreed, some not, during the negotiation phase at an EU level. And for those who are less familiar with the EU negotiation process, essentially, the European Commission proposed a law. It is then negotiated, and alternative drafts are proposed by the European Council and the European Parliament. And then there's a trilogue negotiation, which has now occurred and finalized, resulting in a final text. And we have what is at least very close to a final text right now, today. That doesn't mean that the AI Act is in force yet. So the text is currently going through kind of legalese and legal review within the European Commission. And we should expect final text, I think, to be published probably around the kind of late spring, early summertime this year. At which point, for organizations that are thinking about what does this mean for us, there's a kind of staggered phase of application of the regulation. So some elements of the regulation, we can come into what those are in a few minutes, will apply after 6 months, some after 12 months, some after 24 months, some after 36 months. So there's a very short lead time in some respects for some limited obligations around prohibited AI, and then longer lead times for other elements of the regulation. In terms of actually what the objective of the law is, like big picture, I think it's the starting point for managing our future AI economy. So it's the EU putting down a markers to say, this is the way that we think we should regulate at least high risk and systems that pose egregious risks to our society within the EU and potentially outside the EU as well. So I think it's a very interesting regulation. It is the first comprehensive kind of large-scale regulation of its kind that is focused on regulating AI technology specifically, as opposed to in indirect ways such as privacy laws or consumer laws or competition laws, etc. And I think it has potentially significant ramifications for everyone, whether you're a technology company and you're actually developing AI systems, or you work in financial services or life sciences or retail, whatever sector you operate in, this is going to affect you in some way over the coming years. So it's definitely worth paying attention today and identifying how it may impact you.
Yeah, absolutely. And I would love to get into what some of those key changes are that are coming in the very near future, very, very shortly. Maybe Isabel, I wanted to come to you on this one as well. Any other kind of reflections you wanted to make there? I mean, we've seen with this EU AI Act, it's taken up, you know, it's had a tremendous amount of publicity. It's been given a lot of airtime. You know, why does this matter? Why do you think the Act is so important?
Well, I think it's the EU's way to try and mitigate the risks that come with now increasing use of AI. And it's probably worth giving those who have joined a bit more information around what the kind of key features of the AI Act and what it actually does. So it establishes a risk-based classification of AI systems, and that ranges from prohibited AI systems, which will have to be stopped within 6 months of the EU AI Act coming into force, And then what it does is it provides classification across high risk, limited risk, minimal risk. And then against each of those, it defines corresponding obligations and requirements for each category. So it's a very kind of prescriptive way that organizations will have to demonstrate compliance. And some of the other features are that it creates a European AI board to provide guidance, advice, and oversight as well. It sets up a voluntary conformity assessment scheme for AI systems. And the idea is that it will foster innovation and excellence as well by supporting research, development, education, and so on. Now, this is very different to the UK's approach, which is also, though, very pro-innovation. The idea, and what has come out in the UK white paper, is that rather than bringing in new regulation, then what the UK government is saying is, okay, well, we're going to do this on a principles basis. We're going to have 5 overarching principles for use of AI. So those are safety, security, and robustness is 1, appropriate transparency and explainability is a 2nd, fairness, the 4th, accountability and governance, and the 5th is contestability and redress. And then what they've said is, outside of those principles, we have a lot of law already in place which will help organizations to address the risks associated with AI. Dan touched on some of those earlier. So we've got data protection law, competition, we've also got IP laws. If AI could impact employees, there are employment laws as well. There's financial regulation, competition. So that we've already got really comprehensive law here. So what the UK government have done is they published this white paper. It has these principles. They've also published, DCIT's published an AI assurance framework as well. But what they've asked is for the regulators within the UK, so the CMA, Ofcom, the ICO and the FCA, to all produce guidance by the end of April to really help organizations to consider what are the risks associated with AI. And I suppose the bit that organizations need to think about is if the EU AI Act applies to them, and if this UK white paper principles also apply to them, how do they bring those together and really take a holistic view of the law that could impact them, and how do they also do that in the context of acting in an ethical way and using and really think about how is data ethics embedded into the organization and what they're looking to do with AI.
Yeah, that's a really good point. And I know we maybe thought we'd touch on this later in the conversation, but Tim, I'd love to bring you in here around, obviously we've got the EU approach that's progressing at pace and the UK's approach. What are your thoughts in terms of what international interoperability could look like between those different approaches, and what role do you think sort of standards has to play in that?
So I'm probably taking it slightly back in terms of actually where there is some other similarities as well.
Yeah.
So the EU AI Act came out of an existing sort of product infrastructure in the EU, which is obviously still in the UK. So it's based on regulation that affects sectors like medical devices, toys, and PPE. So there is some certain similarity that already exists there. But I think behind both, there is part of it is a solution around standards and assurance. So parts of the EU AI Act very much push organisations to either have self-assessment or external conformity assessment, and from the UK perspective, there is also a push about using assurance. It's not as much developed as it is for the EU work, but it's still definitely progressing. And from both sides, there is a perspective on using standards, and particularly international standards. So for the EU AI Act, certain standards will end up providing a presumption of conformity. So it's based on a standards request that's gone through to the 2 main European standards bodies, CEN and CENELEC. But again, it will focus through back to international standards rather than European standards primarily. And from the UK side, there's also a strong recognition on the use of standards to help organisations improve their governance. So as part of the recent consultation response to the white paper, there's a document sort of suggesting standards to the different regulators, which Isabel mentioned, but also from the national standards body side of BSI, the government and others have been working on the AI standards hubs, again sort of pushing standards and approach to help organisations achieve good governance in AI as well.
Thank you, Tim. And maybe Osman, if I could come across to you, are there any other kind of significant changes that you've sort of seen through your read through of the EU AI Act that those on the call should be mindful of?
Well, if you mean the life cycle of it so far, if the evolution of it so far, yes, actually, there has been a change since its inception. So when it was first issued as a proposal by the Commission, we didn't have ChatGPT. That created a huge difference. And but the latest text is kind of cognizant of those changes. And when we look at that, we see that now they actually know those practical challenges. They know the dynamism of the field. But the problem is that in its current form, actually, the EU Act is not applicable. It's not practical. It's not enforceable. This is why actually they foresee in general 2-year-old grace period. I mean, it starts with 6 months, as then said, with prohibitions, but it starts with 6 months and it goes until 36 months after the entry into force. The reason is that we don't have those tools now. There are some requirements, there are some obligations imposed on risk levels, risk categories, and now in the latest tech, there's this compromised agreement on obligations surrounding general purpose AI models with systemic risk. And if you look at that, you can see there's this prescriptive language. Yes, it says you should do this and that, but in fact, there's a real legal uncertainty in terms of how those will look in practice. It says you have to have risk management system, quality management system, data governance measures. Yes, we know how they look. So our tools are part of OECD's former CDEI's AI assurance portfolio. So we have some idea on how those things will look in practice, but we don't know eventually how they will look for the purpose of EU Act and after European standardization. So now we have this text, yes, we have seen changes, yes, but in terms of practice, I think we have a long way to go before actually we see best practices, guidelines, and actual practical implementation of the Act.
Thank you. And I'd love to come on in a bit to some of those technical tools that are out there that exist that can help ensure compliance. And maybe, Dan, if I could come back to you, you touched as part of your kind of intro, you were talking a little bit about, I guess, the kind of the timeline for implementation of some of these. Could we unpack that in a bit more detail? Like, yes, some of this stuff will take 2 years, but some of this stuff's less than 6 months away. Would you mind giving us a bit of a breakdown of what that looks like?
Yeah, so I think this is probably also a useful way of introducing the different obligations that apply to different areas of the Act. So if we look at the 6-month timeline, that applies to a category of AI systems that's referred to as prohibited AI. And it's a fairly narrow set of use cases. And something to explain perhaps up front is the AI Act isn't focused on technology per se, in terms of identifying what rules apply, with possible exception of foundation models and generative AI. But generally speaking, it's focused on how you use the system. So you can have the same system being used for a variety of different purposes and being subject to different obligations. So there's a prohibited AI use class, which includes things such as, remote biometric monitoring for the purposes of law enforcement, or influencing people in terms of their emotions in a way that could be psychologically or detrimental to them. So there's a few specific use cases which the EU considers so egregious that they're just prohibited them in their entirety. And those prohibitions come into effect after 6 months. After 12 months, and this won't be applicable for the vast majority of people on this call, I wouldn't think, but the requirements relating to general purpose AI systems take effect. So there's various different ways to refer to them: general purpose AI, foundation models. Essentially, the tools that are forming the basis for so much hype and excitement in this area through generative AI technologies, the providers of those tools will be subject to a whole new framework, which is what Osman was referring to before, which has formed part of the final text, and that framework takes effect after 12 months. So for those organizations, they will have to start for new models that enter the market after 12 months, complying with those requirements at that point. And then the most interesting elements take effect after 2 years or 3 years. And essentially within that is all of the high risk AI systems that are subject to the regulation. High risk AI includes, as Tim was referring to, some of the existing harmonized products such as medical devices, machinery, automobiles, etc. And on the other side as well, a whole range of new categories of AI, which again the EU considers to be high risk because of how it's used, such as for employment and recruitment purposes, or education testing, or remote biometric scanning. So there's a range of circumstances, again, which are considered high risk by the EU. And the requirements there will start to apply after 24 or 36 months, depending on the use case. And what that means in practice is that there's essentially two sets of obligations that apply, depending on whether you're, or two main sets of obligations that apply, depending on whether you're a provider of that system, so the developer of that system, or at the very least a configurer of that system for that purpose, or a deployer or user of that system. So in other words, you've procured a third-party system out of the box or through a cloud service, and then you're deploying it in your own environment to be used for your own commercial purposes. You be a deployer. So primary obligations apply to the providers or developers of AI, and then the secondary obligations apply to deployers. So that's the kind of timeline. So for most organizations, the meat of the regulation will take effect after 2 to 3 years from the point that it's published later this year.
Brilliant, Dan. That's really interesting and a very, very clear explainer. So thank you. I'm sure that was very well explained for many on the call. Maybe Isabel, if I could come to you next, then I'd love to sort of talk about a little bit now about who we think will be impacted by the EU AI Act. From the sounds of it, it sounds like everyone will be impacted to some extent. But are there particular sectors that you think may find the implementation of the Act more challenging than others?
Well, I think to Dan's point, those who are creating the AI are the ones that are going to be, incredibly tightly regulated. I think that is there going to be such an impact for areas where they are already incredibly regulated? No, I think it will be much less, other than kind of additional compliance obligations, but they will have compliance frameworks. They will have the controls in place. There should just hopefully be a kind of uplift and certain artifacts that they might need to create now, like risk assessments or fundamental rights impact assessments and so on. I think for those who are new in this space, it is a very prescriptive set of obligations that they will need to follow. And I think for some organizations, they will see that as helpful because actually they were trying to do things in the right way. And this is really formalizing what the right way should look like. But if you are an organization that is in the UK and you're looking at the kind of government white paper and those AI principles, then what it means is, for them it's, well, do you need to comply with the EU AI Act? Do you want to combine these things together so you have kind of one golden standard, if you like? Probably that's sensible, but it's also very cumbersome. So it will really depend on the kind of the level of maturity of the organization, the size of the organization, how are they placing themselves in the market? What do they want to give as far as assurance that, not only are we compliant with these principles, but we've also mapped the obligations under the EU AI Act and we're also complying with that. So organizations will need to see, A, legally does it apply, but B, from a reputational perspective, do they want to take on that standard?
Yeah, makes sense. Thank you, Isabel. And Tim, I was wanting to come to you. Any reflections on this particular topic? Any, from your perspective, where do you see this act having kind of the greatest impact, particularly in relation to kind of industry and businesses?
I think there's a couple of things of building on what's been said already. It's also worth mentioning that the fact that GDPR has become a gold standard for privacy around the world, that is also a driver behind the EU AI Act. It's written deliberately to be extraterritorial, so it's meant to encompass a lot of organisations who may not realise that it encompasses them. And I think that's, for me, that's kind of one of the concerns. Pretty much as Isabel said, there are organisations who are already regulated, know how this approach works, and it is a change for them, but it's not a huge change. I think there's a whole set of organisations who are unaware that this is coming. For me particularly, it's the sort of Annex 3 organisations like biometric identification, who don't seem to be aware this is coming, don't seem to be aware that part of their market may effectively disappear quite soon. And I think there's a lot of education that needs to happen, both forums like this and the new institutions that need to do to make sure organisations are aware that it's coming down the line, so they have time to make those changes, because it is still quite short, even 2 years.
Yeah, come around very quickly. Thank you, Tim. Just as a reminder to those on the call, if you have any kind of specific questions you'd like to ask the panel, now is your chance, your opportunity. So do think about what those could be, and make sure you pop those in the chat for me to ask them directly. In the meantime, though, Osman, if I just come to you, would you mind telling us a little bit more about some of the potential kind of sanctions or penalties that can be associated with these new changes?
Of course I can. So basically, there are administrative fines actually, and so they range from they range up to 35 million euros, or 7% of annual global turnover, if I'm not mistaken. And these are hefty fines even compared to GDPR. The heftiest fine belongs to prohibitions. But there are 3 levels depending on the infringement, depending on the obligation that was infringed by the given entity. We will have different administrative fines, and of course there are protective provisions for small and medium enterprises. So their fines will be slightly different. They will be issued from the lower end. But the problem is, so I know one of the most practical questions is that when will those penalties will start applying? In fact, we shouldn't be expecting them to apply before we have rules. Before we have practical applications. So the timeline is there. I mean, we also have rules on prohibitions getting applied, getting into force in 6 months. But I don't think we will be seeing any decision on sanction, any issues of sanction on the part of the Commission, even though they have authority to do that when the Act enters into force, actually, before we see practical guidelines, before we see codes, before we see standards, before we see how the Act will apply in practice. And that is probably the main type of sanction we will see under the EU Act. I think all this conformity assessment procedure, this CE markings, certifications, these also kind of imply that the Commission, the European Union as a whole, relies on the market-based selection as well, because you don't have to go through third-party conformity assessment in all cases. But at some point, they will probably go for third-party conformity assessments being the norm, especially for big actors, because if you do that, you will get a certificate, you will get more branding, you will get more prestige. So we will probably see an informal sanction for some actors, but the main form of sanction is actually administrative fines here.
Okay, so it sounds like there may be some kind of grace period at the beginning as people are still getting to grips with this new act. Okay, that's interesting. Isabel, did you want to come in?
Yeah, one thing I would say on that is I would be wary about keeping or about delaying looking at compliance, because I think what is likely, and we've seen it with the DSA as well, the Digital Services Act, is that the European Commission has released quite a lot of requests for information from different organizations. So if you are an organization that is on that radar, particularly the big technology companies, admittedly, but also if you are doing a lot with AI, and you are really going to market quite loudly with the fact that you are building AI, then do be aware that the European Commission is able to request, as an example, that they have come out really quite quickly when it comes to the DSA. So that's probably it is a trend that I imagine we will see continue.
That's really interesting. Thank you. And Isabel, while I've got you as well, we know when it comes to this act that there's a lot of regulation in this space that already exists. This isn't all new. Would you mind maybe unpacking kind of what existing regulations sort of already exist that organizations can leverage in order to try and remain compliant during this time?
Yeah, absolutely. So I guess from a UK perspective, I would say the theme that runs through all of this is going to be data protection. So if you think about during the life cycle of AI, if you think about, the data that goes in, if that is personal information, then data protection law will apply. Similarly, if it isn't personal information, but any data set, you need to think, do you have the right to use that data set? Or is that the copyrighted material, for example, of another organization? Are you being transparent with the way that you're using that data set? So you can apply a number of data protection principles to what you're doing with AI, which will help you with that compliance piece. IP I've mentioned, when it comes to competition, should you have access to that data? Should you be sharing that data? And with each of these steps, with each of these regulations, at each point be thinking, and should I be doing it? So if legally you think you can, okay, but should you be doing it? And then uplift there. If we look at impact on society, for example, the Information Commissioner is looking very closely at how AI is being used, not only using personal data, but the impact that it could have on individuals. And again, all of these are very ethical themes. The other thing to consider is, financial services regulation. If you are supplying this to a financial services organization, what are their consumer conduct rules, for example, that they will have to comply with? Is the AI that you are producing or looking to implement for them, is that going to help them be compliant with those rules or not? So it's looking at it from the other side. And I think if we look at the Digital Regulation Cooperation Forum and the 4 regulators that are feeding in, that gives a really good pointer for looking at the different angles and the different regulatory approaches. I'm sure the others can come in with some more examples as well.
Yeah. Anyone else want to come in with an example? Dan?
I may just add, I think I totally agree with what Isabel's just said. I think just linking all of those things together. So if you're thinking about the AI Act, you're thinking about privacy laws, you're thinking about competition and consumer laws, industry sector laws such as the FCA's consumer duty, all of them have one thing in common, which is they're all focused on the impact of, in their particular domains, but applying it to AI, the impact it has on individuals and individuals' rights. So that's how the kind of ethical perspective also comes in, which is you need to look at, when you're assessing risk relating to AI, not just the risk to your own organization, which may be significant and certainly is a consideration in itself, but also the risk that may be caused through the deployment of an AI system to particular individuals, whether that's your customers, your consumers, your employees, whoever it is. That's the type of thing you need to look at. And I think a really practical way of addressing that at a holistic level is through doing AI risk assessments. And we know that various clients that we work with are already looking at doing those things, which is not necessarily preparation for the AI Act per se, but is actually a good starting point for that, and also addresses those wider regulatory issues that Isabel's mentioned.
Thank you, Dan. And that leads me.
May I add something?
Of course.
I'm sorry. So I love everyone mentioning holistic approach. I love the name of our firm. So I will also tell something about this. I think we should not forget that EU Act may be the first binding legislation, will be the first binding legislation in the EU, but that's not the only regulation in the EU concerning AI. I mean, there are indirectly applicable ones. Yes, GDPR, DMA, DSA, DA, DGA. This letter soup, but there's also this 2 other framework we shouldn't be forgetting about. EU Act is not a product liability regime. It's not a non-contractual liability regime either. So we have another directive for non-contractual liabilities, and we have this product liability, product safety framework. So what the EU Act does is actually about mostly preventive actions, not dealing with the consequences. So there will be design requirements, but it will not actually affect the application. It will not actually make other already applicable legislation redundant. You have to go your harmonized legislation. You have to go your copyright directive. You have to go to the GDPR in any case. So this is just an additional step, just because you're using AI, but everyone mostly remains the same, and EU Act changes only small portions of it. It does not significantly affect the already existing legislation on those issues.
Thank you, Osman. Very helpful. Keen now to move on to, which I think we've started to do already, but move on to the exact title of this webinar, which is really going back to how can we, what's our advice when it comes to helping support UK businesses as they best prepare for the EUA Act. So I'm looking here, I guess, for your best practical advice on what companies should be doing right here, right now. And I would love to hear from all of you on this, because I'm sure you all come from different perspectives. So maybe, Tim, if I could start with you, what are your thoughts on what sort of industry should be doing today?
So I think some of the actual detail of the EU Act is probably a lot more complicated than it sounds like from what was being discussed today. And given the fact that lots of the techUK members are smaller firms, what I'd really advise or suggest is pick up the Act and just read it, because then you can go through the whole process and work out what actually applies to me and what doesn't. I think if it's a large firm, it's significantly more complicated than what I have to do. I think there are a couple of things. I mentioned about the standards that provide the presumption of conformity. The work that Senlec is doing is all open, it's available. Dan mentioned the risk management framework, so it's likely to end up being 23894 ISO around risk management, which is very similar to the NIST risk management framework, which is widely talked about as well. So there's value in doing that, and also one of the ones I talk about a lot. So the management system standard 42001, which is similar to 27001 and 9001 and others, which again touches over lots of different elements and brings this all together. So that's another way to sort of look through and potentially externally demonstrate it as well, but primarily give the thing a read. It's quite logical, but very, very long. So just to warn anyone.
Yeah, so start now. Yeah, absolutely. Thanks, Tim. Isabel, what's your sort of practical advice in this regard?
My practical advice would be think about what is your risk and control framework and what are all of the elements that need to go into that. Organizations have been looking at this not only when it comes to AI, but that first bit, which is really around risk identification. So what are actually the first one it comes to AI, I think, is also value proposition as well. So if you're thinking about AI, what value is it bringing, and is it really going to bring value, or are you just going to have to put another manual process around it? So that value proposition is really important. And then when it comes to the AI Act, it is that identification, Tim said, of your obligations, of your risks. So identify what are your risks, not only your legal risks, but broader risks as well. I think we can get bogged down in legislation, and absolutely compliance with legislation is important, but you do need to look at the kind of broader risk that you need to identify. And then think about, how do you educate your organization about your legal obligations and those risks and how you're going to comply. Compliance really has to be embedded within the culture of an organization. So if you're looking at compliance with AI, with rules relating to AI, it's exactly the same. It really has to be embedded, and that comes through education, it comes through governance, it comes through kind of top level commitment and the board understanding what are the risks and really educating their people. The other thing as well, I think, around AI is consider your workforce. How is AI actually going to impact them? Is there a nervousness around how it's being used? That also, I think, forms part of the framework. I think if you're looking at purchasing AI for use within your organization, then, what is your third-party risk management? How does that fit in with your kind of overall risk strategy? And think about also, how do you ensure that you are monitoring compliance, and how are you reporting on that? What is your assurance? What is your internal audit for those larger organizations? But for smaller ones, do you think about also, where is your kind of independent view of AI risk and AI compliance? There is a number of organizations are pulling together kind of AI steering committees or risk committees, and they're looking at the different elements. And I think also think about who should be part of that conversation, because it needs to be inputted into by a number of different skill sets. I don't think any one person can profess to have all of the skills required to ensure that a company is compliant with the EU AI Act. So think about those different, those different skill sets that need to be brought together and different stakeholders that need to provide input into your compliance journey as well.
Thank you, Isabel. A lot of food for thought there, a lot of sort of tangible takeaways for people. That's brilliant. Dan, anything from your side? Anything you'd like to build on what's been said already?
I think very similar to what Tim and Isabella said. I think just in terms of structuring it and thinking through the kind of logical flow of what to do next, there's maybe like 3 stages in kind of the model that we've produced, which is, firstly, the AI Act doesn't apply to everyone or everything. Just because you're using AI doesn't necessarily mean you have to do very much or anything at all. And that means that actually understanding the potential impact on your organization right now, but also looking forward, because it's predominantly a forward-facing piece of legislation that will apply to future AI systems after the Act takes effect. What is the likely implications? So if we compare the AI Act to, say, the GDPR, is very easy to say what the impact is. If you process personal data and you do so in relation to individuals located in the EU or the UK, you're probably going to be subject to the regulation. It's much more complicated with the AI Act. And the obligations, as we've discussed earlier in the session, really depend on what you're using AI for, and potentially also what the technology is, and also whether it is AI in the first place. So the impact assessment is the starting point for everything, and it determines what you're going to spend your time doing and how much you need to worry about this. Secondly, it is, okay, we understand impact, but how are you going to, what do you need to uplift? So what are you doing currently in relation to compliance, and what do you need to do differently? And this certainly has been mentioned already by the various panelists. Existing frameworks and controls and policies and procedures that you may be able to rely upon to some extent, but there's also a lot of new stuff in this regulation, particularly at a technical level, which is entirely different from what the GDPR requires or other digital regulations, which is going to require some thought, particularly in relation to high-risk AI systems and general purpose AI systems. So what is the gap or the delta between what you do now from a compliance perspective and what you need to do in the future? And then that should help you to understand, well, practically speaking, the remediations and the types of AI governance measures that you need to introduce in the organization in preparation for its introduction. Consistent with what everyone else has said, there's not a lot of time to wait, because actually we've seen it from other regulations. These things creep up on you, and suddenly you're in the phase of, right now you may have 2 or 3 years to prepare for most of the obligations, but very quickly you have 12 months, and it can be impossible to integrate a lot of the measures that are actually required into future AI systems that you may already be developing, which is actually what's required. So if you're launching new AI systems in 12 or 24 months, are you able to comply with these requirements further down the line? And I think that's something to consider. So it's 3 steps: impact assessment, gap analysis, remediations, and AI governance. And just one other point, because I'm conscious that we've touched on it, but maybe it's just worth being really explicit. From a UK business perspective, the reason that this regulation ultimately applies in terms of extraterritoriality is because if you place an AI system on the market in the EU, or you even don't put it on the market, so you don't even touch the EU in terms of selling it or making it available to end users, but it's still being used to produce outputs from that system that affect individuals that are based in the EU, you're within the scope of the regulation. So there's a huge kind of wraparound that the regulations, including from an extraterritoriality perspective, that means that organizations that operate at all in Europe outside of the UK are probably going to be within scope to some extent.
Yeah, that's a really good point of clarification, actually, that the reach of this is so extensive. That's why it does touch upon many companies, even those that don't feel like they're operating in Europe. So thank you for that. Osman, I'd love to come on to you now. We've been talking about, obviously, sort of practical steps people can take. And I know you've got some thoughts on some of the kind of technical tools that maybe exist that can help support compliance. Tell us a bit more about that and what that looks like.
Of course. So actually, the firm predates the EU Act, and I want to start with something general. So there are let's call them competing frameworks all around the world. So that we have NIST. This is not regulation, but this is not prescriptive, but it's there. We have Council of Europe's convention expected to be adopted, and I was part of the negotiation, so it's very close. We have different legislative frameworks, and they have different requirements. So first thing that UK businesses actually at this point have to do is to identify. So create an inventory of their AI system and assess their relationships with the EU, because EU Act is not the only framework there, and our tools and every other tool out there is doing different stuff for the respective framework. So we have this technical framework because EU Act requires establishment of quality management system, risk management system, data governance measures, post-market monitoring systems, record keeping. So there are different technical requirements. And if you just look at the wording, the Act, if you ask me willingly, but for some people by mistake, uses a different terminology for requirements and obligations. So there are technical requirements an AI system has to actually meet, and there are obligations for a given entity. And for providers, the main obligation is to actually ensure that your system meets those technical requirements. So you have to actually create your system, develop your system, deploy your system in a certain way, and that will require some technical expertise, technical assistance. And all of those tools, just like ours, they're trying to actually integrate all of these questions in a holistic approach. So we are doing technical assessment, we are doing AI-based risk assessment, risk management, we are conducting some very automated tests, but we're also actually collecting information from our clients, from AI developers, so that we could give them a document that they could use as a basis for their technical documentation. Let's say we are asking whether they will deploy that in the EU. We are asking whether they have any relationship with the EU. We're asking whether they're actually involved with any sort of prohibited practice, or that may be considered prohibited because of the interpretation risk. So these tools are technical. I mean, what we have is a technical tool, yes, but you cannot actually automate EU Act compliance or any other type of prescriptive compliance with such a tool for 100%. You have to have legal interpretation, you have to have some consultancy experience or input, and you have to have legal interpretation there. So technical tools are just one of them, and we are doing it. So there are 8 design requirements, and currently our tools, according to our calculations, we don't have guidelines, we don't have standards, so that may change. But according to our current evaluations, we are already ticking 4 of those boxes completely, and we're actually helping providers of high-risk AI systems to satisfy the remaining 3. One is quite internal. They have to just draft that and they have to affix that onto product. So there are some very manual stuff as well. But technical tools are important because you have to do risk mitigation, bias assessment, and these things are technical. These are things are not you can do on paper or just asking some questions, because it's all about data and whether your data actually has any sort of bias or has any sort of technical problem can only be evaluated, examined through a technical analysis. This is why we have those technical tools. But I also telling that technical analysis, technical tools alone are not sufficient. We also have to have this proper legal analysis, proper consultancy input as well for a proper compliance.
Interesting. Yeah. So not the silver bullet, part of the tools in the toolkit in order to ensure compliance. Excellent. We've spoken a lot, particularly in kind of relation to the last question around risk management, risk identification, issues around topics around sort of risk frameworks. Another question I kind of just like to ask the panel, because I don't think it's always completely clear cut. Where do you, and maybe Isabel, if I start with you, where do you see risk? In terms of when it comes to risk, where do you see the response? Where should responsibility lie within an organization? Where does it sit?
I think it's a really interesting question, actually, and it's one that organizations have been grappling with. There are a lot of people in a way who want to own this area of risk. I think that's quite a dangerous approach. Personally, I would say that risk, whilst there might be an individual that has overall responsibility, actually the organization as a whole, throughout, every employee everyone throughout the organization needs to take responsibility when it comes to managing AI risk. So if you are using AI to help you with your day-to-day, you need to be aware of the risks and ensure that you're mitigating them. At a board level, you need to understand, that there isn't a systemic issue of risk throughout the organization. So I think I would say absolutely everyone in an organization has their part to play when it comes to risk management, and also to leverage the opportunity that AI brings as well.
I know this is a complex question, but does anyone else have any other views or perspectives they'd like to bring in regards to this question?
Sorry, Tim, please.
I was probably going to sort of reiterate partly what Isabel said. I mean, the EC will determine the standards they use, but from what ones that are likely to be developed around the AI management system, the risk management standard for AI, again, it follows that structure of ensuring that this is known across the organisation as a whole organisation approach. So that is likely something that's going to come through anyway.
Yeah, thank you, Tim. Osman, did you want to do?
Yes, so I just wanted to add one thing. Actually, this was a question that was highly debated during the drafting of the act as well. There's this national competent authorities, and the question was whether we should actually appoint the national data protection authorities as the relevant authority. So because of their expertise on data protection and digitalization stuff or something. Actually, what we see in clients is that if there's a product on which the AI is deployed, that product development, that product department gets the whole responsibility because they know how it works. But if we're talking about legal or compliance departments getting involved, mostly we see that there's the incentive on data protection or intellectual property parts because of the resemblance. But I think we should be careful assigning whole responsibility to data protection units because they are experienced in handling with data protection issues, privacy issues. But what the privacy legislation, what GDPR tries to protect is completely different than what the EU Act tries to do. So underlying principles are different, prospects are different, and technical requirements are completely different. I think that kind of alignment that seemingly comes naturally is also dangerous. So I just wanted to warn that I think there should be a holistic approach. Again, the whole organization, maybe the whole product unit should be taking some level of responsibility in that.
Thanks, Osman. Dan?
Yeah, I was just going to add a bit about, well, I think what approach you take here is dependent on the size of the organization. So if you're a small organization, then you're going to have many fewer resources to dedicate to this than if you're a large or even medium-sized company. But I think if you're on the larger scale, what we're seeing clients doing increasingly is introducing some form of kind of cross-practice or cross-competency AI governance committee. So to the points that have been raised already, it's not that there's a single person who is ultimately responsible necessarily for all AI governance because it's such a complex issue and it requires such a multi-set of skills. But instead, the AI governance committee as a whole is responsible for ensuring compliance, and that includes people from legal, probably. So if you have in-house lawyers, one or more of those individuals may be on privacy, if that's a separate department, and compliance and risk, but also from the actual technical teams. Like so much of this regulation requires actual technical implementation, as Usman has been highlighting, that you can't separate that. So you need people involved from a product development perspective, but also from other areas of the business, such as procurement. If your procurement team is actually involved in bringing on board a lot of these AI tools, HR, if you're introducing employee AI tools, etc. So I think there's a range of different stakeholders that would be participating in that, and that's certainly what we're seeing as best practice at the moment.
Thanks, Dan. Thanks. Very, very helpful. Appreciate all of your commentary on that particular question, because I know it's not an easy one. I'd maybe like to kind of wrap up this conversation. I appreciate we've obviously touched on lots of different areas, spanning lots of different topics. And so there's probably quite a lot for those on the call and those watching the recording to digest. I'd love to try and distill it down to kind of one, which I know is not always easy, but one key piece of feedback or one takeaway for those that are on the call when they, as they go back to their organizations and look at sort of implementing the act within their own businesses. So maybe if I go through just sort of one by one for your kind of last kind of departing words, your last kind of bit of key feedback. Maybe Osman, starting with you.
Well, of course. Well, I think only 3 sentences. First, watch the legislation. Second, identify your interactions with the EU. Third, always do risk assessment, because all of those legislations will require that.
Thank you. Very concise. Tim.
Well, I've referenced out using the AI management system standard as a good approach to start from. I would very simply, pick up the act, read it, and work from the assumption that it applies to you. And so if it doesn't, then that's potentially helpful. But look at it now. Don't wait. That's the one thing I'd say.
Isabel.
Oof, some good points have already been covered. I would say think about how you bring ethics into your approach to AI, either your development or your use of it, and that will get you a good way towards compliance. And then use legislation and the artifacts that it requires you to produce, like those risk assessments, just to evidence what you should already be doing from an ethical perspective.
Thank you, Isabel. And Dan, sorry, and it's always hard to go last when it's a piece of feedback.
Okay.
But,
everything above, but
yeah.
I think maybe to draw out, understanding impact is key. So as Tim was saying, pick it up or ask someone else to pick it up for you. But also part of that in understanding impact is understanding how you use AI. If you don't have an appreciation of what AI systems you deploy or you develop right now or plan to do so in the future, then you're not going to be able to get anywhere with this, because the entire regulation is focused on use cases and how you use AI. So having an AI inventory is like the starting point for this.
Thank you, Dan. Right. Well, thank you, everyone. I've really enjoyed this session. So a huge thank you to my panel. So to Tim, to Isabel, to Osman and to Dan for your time and expertise. We really appreciate it. This is obviously a topic that's not going away. There's lots still to discuss. So techUK will obviously continue to monitor developments in this space. And if anyone on the call would like to be linked up with any of our guest speakers today, then please do get in touch and we'd be more than happy to make those sort of connections happen. So huge thank you for your time again, and yes, have a lovely rest of the day, everyone. Thank you.
Thank you.
Thank
you.
you very much.
Thank you.